first question that anybody asks when they're saying, well, what happens to me if I die without a will is, well, are you married or are you single? If you are married, you are going to be under this logic tree. If you are single, you're going to be under this logic tree. So I think let's go ahead and start over here with the you are married, and then we'll come back to what happens if you're single. Okay, so you are married, you're in the state of Washington, and you die without a will. Does your spouse get everything? Notice that's not the first question. The first question that's asked is, do you have living descendants, kids, grandkids? If the answer is no, here's where we go. This one here, let's start here. And I apologize. I'm trying to make this simple as I can with what is kind of a difficult analysis, but you're married and you have kids or grandkids, etc. If you are, your spouse gets 100% of CP. What is that? Community property. SP is separate property. You live in Washington, you're married, you die without a will, your spouse gets all of the community property. Your spouse gets half of your separate property, and your descendants split the other half of your separate property. So we need to stop right here. What is community property and what is separate property? This is going to be a factual inquiry that is done at the court level. Community property, you would think, is everything you and your spouse own, but that's not necessarily true, because what if at the time of your marriage, your spouse came into the marriage, or you did, with what's called separate property? That is property that was acquired before the marriage. If it's property acquired before the marriage, then that's separate property, not community property, and it is going to go half to the surviving spouse, half to the descendants. Separate property isn't just what is acquired before the marriage, it could be what is acquired during the marriage. So if there is an inheritance from parents, for example, an inheritance is considered separate property, not community property, even though you are married. So that property is going to go, it's going to be separate. So it's going to go half to the surviving spouse and half to the kids. This is all going to happen at a probate. This is not going to be handled outside of the court. And commonly there are questions to the nature of the property. Is it community property or is it separate property? So there will need to be a factual analysis, facts brought in, evidence brought in, a court making the decision. If there is disagreement, which likely there will be between the surviving spouse and descendants, because remember the descendants, or don't remember, I haven't said this yet, the descendants might not necessarily be from the surviving spouse, they can be from a prior marriage. So the relationship might not be an easy, smooth one. So there likely will be lawyers involved, at least 2 lawyers, if not more than that. And there will be a fight or at least an evidentiary hearing based on evidence presented. Is it separate property or is it community property? Which is it? Just as an aside, when we as estate planning and elder law attorneys prepare an estate plan for our clients, we address the issue of what's community and what's separate, so that as if there is going to be a probate, because we want there to be a probate, and even if there's not, there's going to be no disagreement. We're going to have identified what is community and what is separate. That avoids all of that litigation after a death. But getting back to what our circumstances, our scenario is here, this person didn't do a will, so they certainly didn't meet with the lawyer. They didn't do any kind of property status agreement.